Good morning, friends. Today we are dealing with a new topic in jurisprudence, and the topic is classification of rights. Now, in our first video with regard to rights, we had seen what a right is. This is a continuation of that video. Before we start with classification of rights, let's get our basics right. Now, what is a right? A right is defined as an interest which is recognized and protected by law. Or Salmon says, it is an interest which is recognized and protected by the rule of right. Now, when there is a right, correspondingly, if you have a right, correspondingly, there will be a duty to some other person. So if you have a right, there is a duty to some other person. The duty can be for the rest of the world, or the duty can be for a specified number of persons. So the point is, if there is a right, correspondingly there will be a duty. And when this duty is violated, what we term as a wrong happens. So a wrong is the violation of a duty. അതായത് നിയമം അംഗീകരിക്കുന്ന ഒരു താല്പര്യത്തിനെയാണ് നമ്മൾ അവകാശം അല്ലെങ്കിൽ റൈറ്റ് എന്ന് പറയുന്നത്. നമുക്കൊരു അവകാശം ഉണ്ടെങ്കിൽ അതിന് ബദലായിട്ട് മറ്റുള്ളവർക്ക്, ചിലപ്പോൾ ലോകത്തിൽ മുഴുവനാവാം, ചിലപ്പോൾ വേറെ കുറച്ച് ആളുകൾക്കാവാം, അവർക്കൊരു കടമയുണ്ടാവും. ആ കടമ ലംഘിക്കുമ്പോഴാണ് നിയമത്തിലെ തെറ്റ് വരുന്നത്. So this is the basic concept with regard to a right. Having understood what a right is, now let's go for different classifications of rights. Jurisprudentially, a right is classified into various categories. So many of them are there. We will start with the first category. The first classification of rights are classified into perfect right and imperfect right. So the first classification is perfect right and imperfect right. Now, what is a perfect right? A perfect means it's perfect in every sense. A perfect right means you have a right, and that right is enforceable through a court of law. So if I have a right, and my right is enforceable through a court of law, this is called a perfect right. ഇപ്പം എനിക്കൊരു അവകാശമുണ്ട്, ആ അവകാശം എനിക്ക് കോടതി വഴി നടത്തിയെടുക്കാൻ പറ്റുമെങ്കിൽ ഇതൊരു പെർഫെക്റ്റ് റൈറ്റ് ആണ്. For example, I am an owner of a 10 cents of land with a building and a wall surrounding it. I can prevent any person from entering my property. So I say, man Tom, you shouldn't enter my property. And he keeps on entering my property. I can go and file a case and get a restraining order from the court preventing him from entering into my property. So here I have a right, and this right can be enforced through a court of law. Most of our rights are perfect rights. It can be enforced through a court of law. ഇപ്പം എനിക്കൊരു അവകാശമുണ്ട്, കോടതി വഴി നടത്തിയെടുക്കാമെങ്കിൽ അത് പെർഫെക്റ്റ് റൈറ്റ് ആണ്. എൻ്റെ ഭൂമിയിൽ, എൻ്റെ 5 സെന്റ് സ്ഥലവും വീടും ഉള്ള ഭൂമിയിൽ മറ്റൊരാൾ കയറരുതെന്ന് പറയുന്നു. എന്നിട്ടും അയാൾ കയറി എനിക്ക് കോടതി വഴി അയാളെ തടയാം, അല്ലെങ്കിൽ പോലീസിന്റെ പ്രൊട്ടക്ഷൻ മേടിച്ച് തടയാം. So such a right is called by the name a perfect right. Now, what is an imperfect right? An imperfect right is a right which exists, but it is not enforceable through a court of law. ഒരു അവകാശമുണ്ട് നമുക്ക്, ആ അവകാശം പക്ഷേ കോടതി വഴി നടത്തിയെടുക്കാൻ പറ്റുന്നില്ല. So that is called by the name an imperfect right. So you have a right, but it is not enforceable through a court of law. What is that? I will tell an example. See, there are cases called time-barred debts or actions which are time-barred. Suppose you owe me 1 lakh rupee and you have to pay it to me on 2021 January 1st. നിങ്ങൾ എനിക്ക് 1,00,000 രൂപ കടക്കാരനാണ്, ജാനുവരി 1, 2022 നിന്ന് നിങ്ങൾക്ക് ആ തുക എനിക്ക് തരണം. You are not paying it on the particular date. So a cause of action arises. Now you can file a case against this. But you are not doing that. Even though you can file a case, you are not doing that. You are sleeping. So the law prescribes a period. You have to file a case within a period. If you that period will be provided, say, in the Limitation Act or some other law. So if you are going to file a case after the period which is prescribed by the law, then the court will not accept your case. Your case has become time barred. അപ്പോൾ ഒരു കേസ് കൊടുക്കാവുന്ന നമ്മൾ ഒരു പീരീഡ് കഴിഞ്ഞിട്ട് കേസ് കൊടുത്തില്ലെങ്കിലും അത് കാലഹരണപ്പെട്ടു പോകും. So here you have a right, but this right is not enforceable through a court of law. This is called an imperfect right. So in cases of imperfect right, your right is not lost. Your right is still there. ഇപ്പൊ എനിക്ക് തരാനുള്ള കടം അയാൾ കടക്കാരനായിട്ട് തന്നെ തുടരുക. The person who has to give me money still continues to be my debtor. But the only thing is that I cannot get it through a court of law. Such a case is called an imperfect debt. Now, imperfect debt can be used as a defense. For example, he has a case that I should pay him 50,000 rupees. Then I can use this debt to cut off that or set off that. So it can be used as a defense, and it can be used as a security and so many other purposes. But it is not enforceable through a court of law. So this is the first classification of right, that is a perfect right and imperfect right. Now, what is the second classification? The second classification is positive right and negative right. Now, when you study positive right and negative right, our strategy is somewhat different. Now, let's analyze it in this way. A positive right corresponds to a positive duty. A negative right corresponds to a negative duty. Then we will start from negative duty and come to negative right. Now, what is a negative duty? A negative duty means duty not to do something. Duty not to do something. ഒരു നെഗറ്റീവ് ഡ്യൂട്ടിക്ക് ബദലായിട്ട് കിടക്കുന്ന അവകാശത്തിനെയാണ് നമ്മൾ നെഗറ്റീവ് റൈറ്റ് എന്ന് പറയുന്നത്. ഒരു നെഗറ്റീവ് ഡ്യൂട്ടി എന്ന് പറയുന്നത് ഒരു പ്രത്യേക കാര്യം അല്ലെങ്കിൽ പ്രത്യേക കാര്യങ്ങൾ ചെയ്യരുത് എന്ന് പറയുന്നതാണ് നെഗറ്റീവ് ഡ്യൂട്ടി. ഫോർ എക്സാമ്പിൾ, I am the owner of 10 cents of land and a house. Then You have a duty not to enter my property without my permission. You should not. You have a duty not to throw rubbish into my premise. You should not. You have a duty not to paint the walls of my house without my permission. So here they are all not to do. You should not do. You should not jump into. So such forms of duties are called negative duties. Most of your duties are like that. You should not take another person's car. You should not destroy another person's property. You should not jump into or you should not get into his premise. So no. So such types of duties are called by the name a negative duty. And a right corresponding to a negative duty is called a negative right. Most of the rights are negative rights. That is, you should not destroy another person, you should not take another person's property, things like that. Now, what is a positive right? Now, a positive right corresponds to a positive duty. Now, the question is, what is a positive duty? A positive duty is in the nature of to do something to another person. That is, if you have a duty to do something to another person, that is called a positive duty. And a right corresponding to a positive duty is called a positive right. So positive duties are rare. Now, for example, positive duty mean there is a duty for the parents to provide maintenance to their, what do you call, young children, minor children. So this is a positive duty, because if you are an earning person, you have to feed your children, you have to provide food for your children. This is a duty to do something. The duty of the husband to maintain the wife. Duties like that nature, where you have a duty to do something to another person, that is called a positive duty. As I told you, generally duties are negative, and the positive duty, that is the duty to do something. It happens in cases of a contract or something like that. When you have a contract with a specific person, you have to fulfill that contract. So that is what you call a positive duty. And a right corresponding to a positive duty is called by the name a positive right. So positive right corresponds to positive duty. Negative right corresponds to negative duty. നമ്മൾ മറ്റൊരാൾക്ക് എന്തെങ്കിലും ചെയ്തു കൊടുക്കണം എന്നൊരു കടമ വരികയാണ്. ഉദാഹരണത്തിന്, മൈനറായിട്ടുള്ള കുട്ടികൾക്ക് രക്ഷിതാക്കൾ ചെലവിന് കൊടുക്കണം, അവർക്ക് ഫുഡ് കൊടുക്കണം. ഇത് അവരുടെ ഡ്യൂട്ടിയാണ്. അപ്പൊ ചെയ്തു കൊടുക്കുക എന്നുള്ളതാണ് ഡ്യൂട്ടി. അപ്പൊ അങ്ങനെ ചെയ്തു കൊടുക്കുക എന്നുള്ള ഡ്യൂട്ടിയാണ് നമ്മൾ പോസിറ്റീവ് ഡ്യൂട്ടി എന്ന് പറയും. ആ പോസിറ്റീവ് ഡ്യൂട്ടിക്ക് കറസ്പോണ്ടിങ് ആയിട്ടുള്ള അവകാശത്തിനെയാണ് പോസിറ്റീവ് റൈറ്റ് അല്ലെങ്കിൽ പോസിറ്റീവ് അവകാശം എന്ന് പറയും. അപ്പോൾ ഒരു കുട്ടിക്ക് രക്ഷിതാക്കള് കുട്ടിക്ക് ചെലവിന് തരണം എന്നുള്ള ഒരു അവകാശം, അതൊരു പോസിറ്റീവ് റൈറ്റ്. So this is the second classification of rights, that is a positive right and a negative right. A third classification of right is what you call a right in rem and right in person. Right in rem and right in person. No, I'm not going to go very deep into it because this concept is so very deep, but we will go for the preliminaries. A right in rem is a right which is available against the whole world. When you have a right, and for your right, the duty exists for the rest of the world, it is called a right in rem. നമുക്കൊരു അവകാശമുണ്ട്. നമ്മുടെ അവകാശത്തിന് ബദലായിട്ട് ലോകത്തിലുള്ള ബാക്കിയുള്ള എല്ലാവർക്കും നമ്മളോടൊരു കടമയുണ്ടെങ്കിൽ that is called a right in rem. So right in rem means you have a right, and corresponding to your right there is a duty to the whole of the world, rest of the world. That is, if I have what do you call, a watch in my hand or a mobile phone in my hand, then not to take away my mobile phone, not to destroy my watch. This duty lies to all the other persons in the world. So each of you has a duty towards my watch or to my pen or to my cell phone. What are your duties? You should not take away my cell without my permission. You should not steal my phone. You should not throw it away. You should not destroy it. So if you have a right and correspondingly the duty lies to the whole of the world, then it is called a right in rem. That is a right which is available against the whole world. Then what is a right in personam? A right in personam means it is a right which is available only against one person or a specified number of persons. When you have a right and the right is available only against some persons or one person or a specified number of persons or a limited number of persons, it is called a right in person. നമുക്കൊരു അവകാശമുണ്ട്. അതിൻ്റെ കടമ ഒരു വ്യക്തിക്കോ അല്ലെങ്കിൽ ഒരു കൂട്ടം വ്യക്തികൾക്കോ ഒരു സ്പെസിഫൈഡ് നമ്പർ ഓഫ് വ്യക്തികൾക്കോ ആണെങ്കിൽ അതിന് റൈറ്റ് ഇൻ പേഴ്സണും എന്ന് പറയും. For example, if you enter into a contract with a person to buy his car and he gave you his car, and then your duty to pay the price is with you. But this duty is only towards that person. And similarly, if you pay the money, the duty to give the car is only for that particular person. ഒരു ഉടമ്പടിയിൽ ഒപ്പിട്ട് കഴിഞ്ഞാൽ അയാൾക്ക് മാത്രമേ നമ്മളോടൊരു കടമയുള്ളൂ. ലോകത്ത് വേറെ ആർക്കും നമ്മളോട് കടമയില്ല. So in contract and all, there is what you call right in personam. Usually there is a question which is asked in the examination. What is the nature of a right of a state to collect taxes from the citizens? ഒരു രാജ്യത്തെ ഗവൺമെന്റിന് വ്യക്തികളിൽ നിന്ന് ടാക്സ് മേടിക്കാനുള്ള അവകാശം അത് റൈറ്റ് ഇൻ പേഴ്സണം ആണോ റൈറ്റ് ഇൻ റം ആണോ? That is state's right to collect taxes from its citizens, whether it is a right in personam or right in rem. We may usually get a feeling that it is a right in rem because the state is collecting taxes from everyone. But that is not it. It is only a right in personam because state has no universal right to get universal or uniform taxes from everyone. The state will collect, say, 10,000 rupees from me as a tax. From another person, the state will be collecting 5 lakh rupees. From Ambani, the state will be collecting crores of rupees. From some person, they won't be collecting any fee, any tax at all. So a state's power to collect taxes is actually a collection of rights in personam. and it looks like a right and wrong. So this has to be kept in mind. Now, connected to the area of right and personam, there is another concept called jus ad rem. Jus ad rem is a part of jus in personam. Jus ad rem means a right to a thing or a right to a right. ഒരു അവകാശത്തിൻ്റെ പുറത്തേക്കുള്ള ഒരു അവകാശം എന്ന് പറയാം. കുറച്ച് കൺഫ്യൂസിംഗ് ആണ്, ജസ്റ്റ് ഒന്ന് മനസ്സിലാക്കിയിരുന്നാൽ മതി. Jus ad rem means a right to a right. For example, I enter into an agreement to buy property in future. Here I am not getting the property, I get only a right to buy the property in future, or right to get married or a contract to marriage in future. These are examples of jus ad rem. Just keep in mind, because it is a connected term. So this is the third classification, right in personam and right in rem. Now the fourth classification is proprietary right and personal right. Now what is proprietary right? Proprietary rights means any right in anything which involves property or anything which is connected with economic value or property. A right over something which is in the nature of a property. നമ്മുടെ സമ്പത്തുമായിട്ട് ബന്ധപ്പെട്ട് സ്ഥലങ്ങൾ അല്ലെങ്കിൽ വസ്തുക്കൾ. So proprietary rights can be rights over any form of property, movable property, immovable property. Just like you have right over land, you have right over your car. Then it can also be intangible property. Your right to your proper patent right, your copyright. So anything connected with money, economic value, wealth, etc. can be termed as proprietary rights. So it has an economic value or content. Now, distinguished from proprietary right, there is the personal right. What is a personal right? Personal right is a right which comes out of status. It directly doesn't have any property component. It comes out of relationship. അതായത് സമ്പത്തിൻ്റെ ഡയറക്റ്റായിട്ട് വരാതെ ആളുകൾ തമ്മിലുള്ള ബന്ധങ്ങളിൽ നിന്നുളവാകുന്ന ചില അവകാശങ്ങളെയാണ് പേഴ്സണൽ റൈറ്റ് എന്ന് പറയുന്നത്. ഒരു ഭർത്താവിൻ്റെ പുറത്ത് ഭാര്യയ്ക്കുള്ള അവകാശം, ഭാര്യയുടെ പുറത്ത് ഭർത്താവിനുള്ള അവകാശം. For example, the right of the conjugal relationship between the husband and the wife. It doesn't have a direct economic content. It arises about as a result of the status of the party. So such forms of relationship where there is no economic content but arises about the relationship of the persons, this is called what you call a personal right. For example, your right to life, that is a personal right. Your right to good reputation, that is a personal right. But if someone defames me, I file a case and the court orders an amount of compensation. My right to get that compensation becomes a proprietary matter. That is different. So, personal right is a right which involves relationship and personal status of a person, whereas the proprietary right is something which involves wealth, economic value, and property of a person. So this is proprietary right and personal right. It's not very exact classification. but just to get an idea. Now this proprietary right can again be classified into two. The proprietary right itself can again be classified into two. That is right in re propria and right in re aliena. Right in re propria, right in re aliena. Now what is right in re propria? Coming to property rights. When you have a right over your own property, it is called right in re propria. That is your right over your own property. Usually that is how it happens, is it not? That you have a right over your own property, that is the usual thing. So when you have a right over your own property, like when you have a right over your house, your car, your building, your apartment, all these things are right in re propria. Now there is something called right in re aliena. How does it happen? When you have a right over another person's property, it is called right in re aliena. How does it happen? When you are having a right over another person's property. അതായത് നമുക്ക് നമ്മുടെ സ്വന്തം വസ്തുവിൽ അവകാശങ്ങൾ വരുമ്പോൾ proprietary rights വരുമ്പോൾ it is called right in re propria. നമുക്ക് മറ്റൊരാളുടെ പ്രോപ്പർട്ടിയിൽ അവകാശങ്ങൾ വരുമ്പോൾ that is called by the name right in re aliena. How does it happen? Suppose you have say you have a land and you have a right to weigh over your neighbor's property because your house has no other way. Therefore, you have a right to passage or right to way through your neighbor's property. Here, there is a right to way. What is the right to way? You are having a right to walk through your neighbor's property. And here you are having a right over another person's property, and this is called right in re aliena. നമ്മുടെ വസ്തുവിന് വഴിയില്ലാത്തതുകൊണ്ട് നെയ്ബറിന്റെ വഴിയിൽ കൂടി നടന്നു വരാനുള്ള അവകാശമുണ്ടെങ്കിൽ അവിടെ നമുക്ക് മറ്റൊരാളുടെ വസ്തുവിനെ പുറത്ത് അവകാശം കിട്ടുകയാണ്. This is an example of right in re aliena. And this right is called an easement right. ഈ അവകാശത്തിന് ഈസ്മെന്റ് റൈറ്റ് എന്ന് പറയും. For example, in this example, the property which is benefited by the right to way, that is my property, is called dominant heritage. ഈ കേസിൽ ഏത് വസ്തുവിനാണോ ഈ നടപ്പവകാശം കൊണ്ട് ലാഭം കിട്ടുന്നത് അതിനെ ഡോമിനന്റ് ഹെറിറ്റേജ് എന്ന് പറയും. The property which is subjugated by this right to way, that is my neighbor's property, it is called by the name servient heritage. ഈ നടപ്പവകാശം കൊണ്ട് ന്യൂനത ഉണ്ടാകുന്ന വസ്തു ഏതാണോ എൻ്റെ നെയ്ബറിന്റെ വസ്തു അതിനെയാണ് സെർവിയന്റ് ഹെറിറ്റേജ്. And the right of me to walk through my neighbor's property, it is called by the name easement right, or this right, easement right. So dominant heritage, servient heritage, easement right. This is an example for right in re aliena, or right over another person's property. Now the next classification of a right is principal right and accessory right. Principal right and accessory right means when you get one principal right, one right, along with it you also get some other rights with it. For example, I buy a 10 cents of land. Now this 10 cents for this 10 cents of land, there is a right to walk through the neighbor's property, the right to take water from another neighbor's property. So when I get this 10 cents of land, I also get the right to walk through that neighbor's property. I also get the right to take water from a third neighbor's property. So my fact of acquiring the property is called the principal right, and my right in acquiring the other rights, right to weigh and right to take water, it is called the accessory rights. ഞാനൊരു 10 സെന്റ് ഭൂമി മേടിക്കുന്നു. ആ 10 സെന്റ് ഭൂമിക്ക് അടുത്ത ആളുടെ വഴിയിൽ പറമ്പിൽ കൂടി നടന്നു വരാനുള്ള അവകാശം ഉണ്ടായിരുന്നു ആ ഭൂമിക്ക്. അതുപോലെ മറ്റൊരു നെയ്ബറിന്റെ പ്രോപ്പർട്ടിയിൽ നിന്ന് വെള്ളമെടുക്കാനുള്ള അവകാശവും ഈ ഭൂമിക്കുണ്ടായിരുന്നു. അപ്പം ഞാൻ ഈ ഭൂമി മേടിക്കുമ്പോൾ അത് പ്രിൻസിപ്പൽ റൈറ്റ് ആകുന്നു. അതിനോടൊപ്പം തന്നെ വെള്ളമെടുക്കാനും നടക്കാനുമുള്ള അവകാശം കിട്ടുന്നത് ആക്സസറി റൈറ്റും ആണ്. So this is called the principal right and the accessory right. Now the final classification of rights is between what you call legal and equitable rights. And the legal and equitable rights is only a historical classification. Because in an earlier period in England, there were two types of courts. The common law courts, which was created by the parliament, and the chancery courts and the what you call the equity courts, which was created from the king and council and all. So equity courts and common law courts were two categories of courts in England. Laws or rights recognized by the equity courts were called the common law rights, and those or legal rights, and those what you call recognized by the equity courts were called the equity rights. There are other classifications also, because what do you call public and private rights, we will study later. Now these are the major classifications of rights. This is an area which is repeatedly asked for examination, either as an XC or sometimes as short notes. Thank you.